Hi, and welcome to the Wake podcast. I'm Taylor Kaufman.
And I'm Alejandra Moreno.
And today we're going to be talking about probate cases, or the different types of probate cases.
Yeah, so there are two in Florida well-known probate cases, and it's kind of like the full or the mini, right? There's the formal administration, which is the probate case that everybody knows about. You want to talk about what that looks like, the process of a formal administration?
Right, so formal administration is when a probate case is opened up. Someone is appointed as a personal representative. A 90-day creditor period is usually initiated during a time, we're liquidating bank accounts, we're selling properties if they needed, we're marshaling all the assets into the estate. If any creditor claims come in, we speak to the client about it. We either try to negotiate those claims down, or we will try to get them, stricken from the case. But it's usually a longer process. But it's what, like you said, most people think about when they think of the probate case.
Longer and more expensive,
Yes.
right? But sometimes with the size of the estate, if somebody passes away with or without a will, we have to do the formal administration. And then there's also the summary administration, which is like a mini probate, right? And the requirements for a summary administration is the person has to have passed away, has to be more than 2 years, or the estate has to be less than $75,000, which does not include what's called exempt property. What's exempt property? Your homestead is exempt, a car can be exempt, that's about it. And the reason why it's that mini probate, it's a summary, is because instead of having a personal representative appointed, having a creditor's period, it's just a transfer of title.
Right.
So in a case that just has a house, we're really only getting one order, an order determining homestead. And it just says this person passed away with this property, these are the beneficiaries. We record that in the county, and it's almost like a deed. Once it's recorded, the property passes from the deceased person's estate to the beneficiaries, and that's it. If somebody has a very small estate, less than $75,000, we just get one order that basically tells the bank, whatever bank, cut checks payable in these amounts to these beneficiaries, and that's it.
Yes.
But there are risks to a summary administration. You mentioned the creditors period. There is no creditors period, but that doesn't mean there's no creditors.
Right, and that's kind of one of the ways that a summary administration can go sideways.
Yes.
So let's say we open up a summary administration, there's no notice to creditors, but in between the time that we're opening it and we're obtaining that order, like you said, that we're recording, there can be a creditor that files a claim.
Yes.
And when a creditor files a claim, there's kind of some options. We can either, the client can either pay, for the claim, or they can try to negotiate it down. But a lot of times, or sometimes, all we have to do is we have to upgrade that case to a formal administration. So we basically have to kind of open up two, probate cases. It was a summary, but now we have to upgrade it so we can try to strike that claim and get it removed.
Or sometimes it depends on the creditor, right? It depends on the judge. It depends on the type of claim.
Yes.
Some claims, and we don't see this often, but some creditors of a decedent, you got to pay. A mortgage, construction lien. Those are creditors that attach to the property.
Yes.
So we're not going to be able to do anything. For a summary administration that just has a homestead, and let's say a credit card, creditor files a claim for whatever, $50,000, that claim is not attached to the property. So technically you could get the order determining homestead and transfer the homestead because the homestead is protected. But again, it depends on the creditor, it depends on the judge, it depends on so many things that sometimes we have to say, we can give it a shot, but it's really up to the judge.
Yeah.
And
that's a good point. Yeah, it really is up to the judge and, what the claim is.
What the claim is, yeah. But I've said in previous podcasts, that a will is a great tool. And, we're talking about the headache of, formal administration, a summary. But if you just have a house, and, I'm not crazy about selling a trust to somebody that just has a house, because a trust might be more expensive than a will plus a summary administration. And it might be kind of a headache for an elderly person that just has a house. So a will is still a great tool, especially if you just have a house or you don't have a huge estate. It's still a great tool. And, maybe that's going to be a much better option than doing some complex estate planning that you don't need.
Right. It really depends on the assets and what you need. And I think that's what makes the estate planning experience. It's very tailored to the person and what they need.
Absolutely. You have to have an attorney that knows what question to ask. And, inform the client. you can do a will, but this is what the future looks like.
Yes.
Or you can do a trust, and that's what the future, or maybe you can do a ladybird deed. There are many options, but it depends on the person's assets. It depends on the family dynamics, right? Because you don't want to do a ladybird deed when you have siblings that don't get along and then they're stuck with a property. Or maybe you want to avoid probate and pay for the trust because your kids don't get along. They're not going to be able to co-own property.
Right.
And you just want to leave instructions, upon my death, I want my trustee to sell my property and then just distribute cash. Or you say, you know what, my kids get along great. The trust is kind of out of my budget. Let's just do a simple will. That'll maybe accelerate the summary process a little bit. It doesn't break the bank. It leaves my wishes. And then my kids, once the property is transferred to them, they can sell, they can do whatever. One can keep it, they can buy each other out. They get along, there's no problem.
Definitely.
Not always the case, but
yeah, it is not always the case. But I think that it's a great point. A lot of people want to do these estate plannings to avoid probate, but like you said, in some situations, it's okay to go through probate, especially if it's a summary administration. If it makes sense for your case, then there's no issue with doing probate.
Yeah. Let's, since we kind of blew by the formal administration, I guess, let's talk a little bit about what that process looks like when we have a client that does need a formal administration. So we're going to ask the client for certain documents, right? The court has to keep an original death certificate. If there's a will, we need an original will.
Yes.
And that is an issue because a lot of times people don't keep their will in a safe place or nobody knows where it is.
Yes.
And there is another process for asking the court to accept a copy as an original. But now we're dealing with, witnesses. We have to depose people. That can get expensive. So it's very important to keep your original will, if you have one, in a safe place and to make sure your personal representative knows where it is.
Of course.
Right? So we draft all the opening documents. Like you said, we open the case. So we file everything with the court. We get a case number. Now we're going to send the original will and the original death certificate to the court so they can link it up with their case. And we need to get consents from the beneficiaries. So even if your will names a personal representative, I want my oldest daughter to be my personal representative, everybody else has to consent.
Yes.
Right? Because based on the statutes, everybody has kind of the chance to be appointed, but a judge is going to look to the will, right, and follow the deceased person's wishes. But maybe the decedent wanted their oldest daughter, but the other siblings are like, no, she has issues, she can't serve. And now that turns into another little battle.
Yeah.
Right? The personal representative in a case is the only one that needs an attorney. Beneficiaries technically don't need an attorney, but sometimes they get one.
Yeah,
right?
sometimes they do. Or sometimes, we but we like to explain the process to them. So even though they don't get an attorney, we kind of feel like we help them along the process. We're not representing them, but there's a lot of questions to foreign, people have never been through probate, so they have a lot of questions. And
yes. And it's convenient to have everybody on the same page, right?
It is.
We don't want this to turn into, a more complicated. It's already a tough process. You're already dealing with the loss of a loved one. The personal representative has a big responsibility. So we like to keep everybody informed.
Yes.
It's not just sending somebody a court document and be like, hey, sign this and notarize it and send it back to us. No, we want to know what you're signing.
Yeah.
We want you to know what you're signing.
Of course.
We want to make sure we explain it to them as well, right? Treat them like they're part of the process because they are.
Yeah.
So let's say we go ahead, we appoint the personal representative. We get an order from the court saying this person is the personal representative, which is a fancy word for administrator, right? The other areas of the state call it an executor or executrix. But we have the personal representative appointed. And then if it's been less than 2 years since this person passed away, we need to publish their death. And why do we publish their death?
So in Florida, we have to do a 90-day publication period, which is essentially letting the creditors know that this person has passed away, and if there's any, claims or any debts that they have, then they can file a claim in the estate.
Right, to try to get paid from the deceased person's
Yes.
assets. And during those 90 days, we are liquidating any bank accounts that were in the decedent's name alone, and this would be accounts without beneficiaries, right?
That's important.
If there's real estate and nobody wants to keep it or nobody wants to buy it, we sell it. Sometimes beneficiaries want to buy it from the estate. So an estate with 4 beneficiaries, one is entitled to 25% of the property, so they just have to pay 75% to their other beneficiaries, which is nice in South Florida, the benefit that properties are so expensive if you can buy them out, right? But yeah, we've seen that. Otherwise, it's sold. The judges in the last few years have gotten very strict on fair market value. Back when I started practicing a long time ago, probate properties were kind of seen like a great deal, like fire sale. But you've seen, what kind of requirements do judges have to make sure that it's being sold at the correct value and it's not being let go at a fire sale?
Yeah. So, now you need to have a realtor basically prepare a comparable market analysis to show the judge, or just it's a document that basically says what the property should be sold at, what the fair market value is. And then we also need a broker's letter basically saying that the realtor prepared this comparable market analysis and they believe it's a fair market value and with their license number and everything. So it's not like you can just kind of go on Zillow and just print that out and submit it. Like, the judge really wants to know and make sure that this is being sold at fair market value.
Or sometimes if a property has a certain value, we need an appraisal. Like CMA, the comparable market analysis is not enough. We need an actual appraisal so the judge knows the value. And a lot of clients complain about this, but I think it's the right thing to do, because at the end of the day, the judge is looking after your best interest and making sure that you're not getting ripped off.
Yes. And sometimes beneficiaries are frustrated over this. Like, they're like, we all consent. We don't. We want to sell to this person for lower than fair market value, but like you said, the judge really is making sure that it's in the best interest of the estate, that they're selling it for what they can sell for, what it's worth.
So that is, I think, even though it's an extra step, I think that's great that the judges are requiring that. And then once the property is sold and the accounts are liquidated and the 90-day creditor period has expired, we're just going to basically petition the court to distribute. So everything that we liquidated is put into a court blocked account. No money can come out of that without a court order. So at the end of the case, the personal representative, if they want to charge a fee for their services, they can. Under the Florida statutes, that's allowed. Everybody's going to have to consent.
Yes.
And the judge is going to have to approve. And then after, fees are paid, personal representative's fees, attorney's fees, everybody, then it's just the final distribution where everybody gets their check or, whatever is left to them in the will. And then we're ready to close it up. I know it sounds like the 90-day creditor period, we do all these things, and at the end of the 90 days, we distribute. But you and I both know closings can take a long time.
Right, for the real estate, yeah.
There can be an issue on title. Liquidating accounts sometimes, depending on the bank, can be a hassle. So a formal administration ideally should be quick, and we try to keep the ball out of our court as much as possible. If we get a notice from the court, we try to resolve it and get it, back out, so that the estate does not go too far after those 90 days. But the reality is, most formal administrations, you're looking at about a year. Yeah. Unfortunately.
If there's property and if there's complex investments too. But, if it's a simple bank account, I think we have that pretty, if it's like Bank of America or like a regular, bank, we have those orders ready to go. And But yeah, it can take up to a year. And
it can take up to a year. That's what most people, most probate attorneys are looking at, about a year. We try to squeeze it as much as we can, but unfortunately, it's the nature of the beast. When you're at the mercy of the court, you're at the mercy of the banks, you're at the mercy of the closing agent is selling the property, you're at the mercy of the realtor that has to list it and get a buyer. Yes. So it's a lot of moving parts that are just out of our hands. But like I said, we try to, when the ball's in our court, get it back out as quickly as possible, so there's no downtime on our end. Yeah. And that's how we try to move our cases.
Yeah, it's interesting because I feel like when clients first come in for the probate and we have the opening documents for them, like, we have them sign a lot of documents, but and they're kind of overwhelmed at first, but we're really having everything teed up. We're having the bank letters, everything squared away, so that way when we open the case, we are just ready to go. And obviously the client is involved in the case, but we don't like to send them a bunch of different documents to sign here and there. We have everything signed, and we're like, we're sending this out, just giving them updates.
Yes,
but it's a process.
It is. It's a process. But we know the process, and I think we navigate it very well. But definitely you want to make sure that if you're dealing with probate, that you are going to an actual probate attorney. You're not going to somebody who just wants to help you out, because it is a complex process with a lot of moving parts. So you want to make sure that you have the right representation.
Of course, yeah.
Right. Well, thank you for joining us. Follow along for more insightful podcasts. This is our 101 series, which is going to be basically just the basics of estate planning, guardianships, and probate. So if you follow along, future podcasts will get more into the details, but you can always refer back to these episodes so you can get, a general knowledge and understand us better. So thanks for joining us. And from ASM Law Group, preserving what matters most for those who matter most. The Wake is for informational purposes only and does not constitute legal advice. The discussions in this podcast are meant to bring awareness to important issues, but they should not be considered a substitute for professional legal guidance. If you need legal advice tailored to your specific situation, please consult a qualified attorney.